Okay, so last time we were talking about some of the discussions of what was going on in terms of the tort, and we talked a little bit about bankruptcy and litigation costs, and we talked about how insurance industry is somewhat of a privatization of the tort law, where the insurance companies will insure you against liability, and they will also make it so that you don't have the ability to sue the person who caused you the injury. They do the suing. And we talked about if you have universal insurance in competitive markets, then it would be basically a contract between the insurer and the insured, and then the insurance companies would debate over the settle the litigation. So, so basically we were talking about, as I said, behavioral economics, rationality. These are basically just looking at some of the assumptions and analysis that we had looked at in terms of the economic analysis for tort liability. And what we're going to talk about today is a little bit of an expansion here about what happens if you have special cases. And in particular, we're going to look at a special case of vicarious liability. And vicarious liability is, can the owner of a company or could a franchise be held responsible for the actions of the franchise owner, or the franchisor be held responsible for the activities of the franchisee, or could you as an employer be held responsible for the activities of one of your employees? Okay, so just by an example, if we looked at McDonald's, and what happened was you as the franchisee, you have a McDonald's franchise, and let's say you don't cook the hamburger right, or one of your employees doesn't cook the hamburger right, and then somebody gets sick, who could be sued? Under vicarious liability, you could have it so that the McDonald's, the company, right, they could be sued, or you could have it that the owner of the franchise, you're the franchisee, they might be sued. And so why would you might want to have that? Well, if you did, then what would happen is that the McDonald's would be careful about McDonald's would be careful who they allow to become a franchisee. Or if you're an employer, you'd be careful and screen what your employees look like. You'd be careful to screen your employees. And another reason that you might want to think about that is that the employer or corporation might know more about the precaution than the individual employee does. So McDonald's might know more about what the proper method of cooking the hamburger is. Or let's say you are working at you're working at a manufacturing plant. The people who are running the manufacturing plant would know more about what you should be doing to have proper expectations, right? So to try to reduce the proper precaution, okay? So the employees will perhaps know a little bit less, and that would give you an example where we were talking about earlier about the producer of the chainsaw may know more about the probability of an accident than would the consumer, and so then we'd want to have it so that you have the liability for an accident falling on the producer of the chainsaw, and then the proper the proper precaution will be put into the production of the chainsaw, and so that'll end up in the total cost of the chainsaw when you go to buy it. Similarly here, I, as McDonald's, may know more about what the proper precaution we ought to be taking than an individual franchisee. And of course, then what you might have is that the McDonald's would train the franchisee, or the owner of a business would train their employees on proper precaution for things. So you could have strict vicarious liability. Remember, we were talking about strict liability. You can have strict vicarious liability. And in strict vicarious liability, the employer is liable if the employee caused the harm. So it's strict liability. Or you could have a negligence rule. We're just looking at what we had looked at before in terms of tort law. You could have strict liability, you could have no liability, you could have a negligence. And in this case, you could have strict liability, or you could have that says, okay, I have to show that if I'm going to sue the owner of the business, I have to show that they were negligent in supervising their employee. And of course, that might be a little bit difficult to do. But one of the points that to be made here is under strict liability. If you had strict vicarious liability, then what might happen is the employer might misreveal or not reveal damages that are occurring. Okay? The employer might not reveal damages that they know about. If you looked at, for example, there was a case where one of the employees of Michigan State University, their gymnastics coach, Nasser, was sexually exploiting some of the gymnastics students, and Michigan State was not revealing it. And Michigan State ended up settling a $500 million, MSU settled for $500 million for the victims of the employee, that is Nasser. Okay? So here was a case where you had vicarious liability, and the argument that one might use to say, if you have a strict vicarious liability, then Michigan State might not let people know that this thing is going on. If you have negligence, then they might. If you have a negligence rule, then MSU, what they might have done is they might reveal, okay, and show they were not negligent. Right? So if it's a negligence rule, I might say, oh, okay, I know these things are going on. I know this, that Nasser has been doing these bad things. And what I'm going to do is I'm going to explain to you why I wasn't negligent. So they might reveal this in a way to give themselves a negligence defense. Of course, that might be very hard to prove. Right? So when we look at the administrative costs of a negligence rule, we might say that negligence would be, again, hard to prove. Now, what you could also have is what's called joint and several liability, and you could have that with or without what's called contribution. So, what do we mean by joint and severable liability? Okay. This is a case where more than one party causes an accident. Joint and severable liability. So we just got through with vicarious liability. The second thing that we're going to talk about is this joint and severable liability. So this was, again, vicarious liability. And this is not the issue of whether I should have an employer be responsible for the actions of the employee. As I said, if again, we're looking at what's the economic incentives. If we set up the law this way, here's what's going to happen, or more likely to happen. If we set up the law this other way, here's what's likely to happen. And we said that if you had vicarious liability where the employer or the owner of the franchise or whatever is liable, then they will undertake certain precautions, and it might be the case that they are best able to take the precaution or know more about what the precautions ought to be. And so you'd say, okay, that's the case where we ought to have that. If we are, and then we just looked at what this does in terms of, do you want to have a negligence rule like we did under the regular tort when we were talking about tort liability in general, and we just talked about what's the incentives in either case. Here we're looking at, okay, what if there's more than one party causes an accident or causes an injury? If we were to look at this, then let's say you go in to have a surgery, and you go in to have a hip surgery, and when you come out, something terrible has happened. You have picked up some sort of disease or something while you're in the hospital, or you weren't properly put out in anesthesia. And so the idea would be is that when there's a lot of parties that could have caused the accident, and you may not know who did it, can you go out and do you have to figure out, oh, it was the anesthesiologist that caused the problem, or it was the surgeon that caused the problem, or it was the hospital that caused the problem because they didn't sanitize the instruments correctly or whatever. So it might be very difficult for you to know who caused the problem and to show who caused the problem. So if more than one party can cause the accident, then we have what's called joint liability. Okay? So if more than one party can cause the accident, you can have joint liability. So let's talk about joint liability for a moment. If you have joint liability, you can sue all the parties at once and collect from the group. You can have one suit. Okay? You can sue all the parties at once. Okay? So you have one suit, and you can collect from all of them as the group. So in a joint liability, if there were three people that caused the accident, let's say there was somebody that was, two parties were driving too fast, and there was a pothole in the road, so that the county didn't fix the road correctly, and one car crashes into another car, and then that car crashes into your car, then can you sue all? Can you sue everybody? Can you sue as a group? Can you sue the two, the two drivers and the county itself? If there's several liability, if you have severable liability, then you can sue each separately. You can sue each of the parties separately if you have several liability. And so you can have a distinct trial for each of them, right? So you have a separate trial, and you can collect from each. So you can collect from each party. Now, you can also sue each party for the total, or you could sue each party for part of it. And if how we're going to bring in what's called contribution here, you could sue each party for the total accident, right? The total compensation. Right? So I can sue each party I have a separate suit against this person, separate suits against this one, separate suit against the county, and I can collect compensation from each of the parties. Now, what's called, if you add with contribution, well, what that means is that you can't get more than the total amount of damages, right? Like, so I'll give you an example here in a second. You can't get more than the total amount of damages. So, for example, suppose that you're injured and there's $100 in damage. Okay, so $100 in damage to you, and you're injured, and Party A and Party B caused the accident. Two people, Party A and Party B, they caused the accident. So what you could do, if you have several liability, then you can sue A and B separately. Okay? So under severable liability, if you have severable liability, then what you do, you can sue A separately from B. You can have two trials. Okay? And you can collect from each. Under severable liability with contribution, I couldn't get, let's say I get $100 in damage, and what I do is I sue A. Okay, so I hire Bernstein Law Firm or whatever, and I sue Party A, and I'm awarded $90. I could then go on and sue Party B, but if I sue Party B if we have joint and severable, if we have severable liability with contribution, and I sue Party B, then I can't get more than $10 from Party B. Now, what that means is that you could sue the party. Why might we want to do this? We might want to do this is that you can sue the party that's most likely to be able to reimburse you if we have this ability to have severable liability. I could just sue A if A was if let's say A was a wealthy entrepreneur, and B was their assistant, you're more likely to get reimbursed from party A than you are from party B, what you could do is you could sue A, and then you could sue B separately to get whatever else that the court didn't award you. So if you had $100 in damages and you were awarded 90 from party A, you could turn around and sue B for the rest of it. Now, then if you have a comparative negligence, and remember that we were talking about comparative negligence where you are responsible for the amount that you added. So if you caused 30% of the damage, you had to pay 30% of the compensation when we were looking at tort in general. If you had that, if you have comparative negligence, if that was the rule, okay, so if you have comparative negligence, then what would happen is that and remember that was one of the 4 types of negligence rules that we had. Then what could happen is that A would then have to sue B to get their share. So suppose that $90 was awarded, and let's say then A would have to sue B to get from B their share of the negligence, right? So if you were 30% responsible, then you'd have to give to and A sued you and A won, you'd have to give them 30% of the cost of the awarding of the damages. All right, let's make just some observations about if you have joint and severable liability. Okay, again, joint liability meaning I can sue everybody that was involved in the accident. I don't have to prove who caused it. Severable liability says I can sue each party individually. So. One of the first observations about joint and severably liable, okay, if you're looking at both of those ways of doing it, right? So if you have joint and severably liable, and let's just look at some observations about it. First observation is that you don't need to prove who caused the harm. Right? You're the injured person and you're bringing a suit. You don't have to show or prove who caused the harm. And of course, if you were, like I said, in a hospital situation, you don't have to know, and of course, it may be hard for you to know that information about whether it, like I said, whether it was the person who prescribed the drug, or did somebody not sterilize the instruments, or was it a failure of skill of the anesthesiologist, or was it a failure of skill of the surgeon? You don't have to do that. You just have to. You can sue the group, and then it shifts to the defendant to try to show who caused the liability if they want on their end. So it makes it easier for you as the victim to receive compensation for an injury. A second thing is that, and maybe we should just point that out here. It's more likely that the victim will be able to get compensation. right? Because I don't have to do that extra step of figuring out who caused it. And of course, if you thought about that a little bit, it would make it so that all the parties involved would take precaution, right? And if you are the surgeon, you may make sure that the hospital sterilizes the instruments, right? So again, we want to sort of look through what are the incentives when you for the people to take proper precaution, because that's what we're talking about in tort liability, right? We want people to take efficient precaution. It makes it so that all of the defendants now, or possible defendants, will be looking at the other parties to make sure that they're taking proper precaution. Second thing is you could, you're more likely to recover your damages because you can sue those people who's most able to pay, right? So basically you can sue the deep pockets or sue the people most likely to pay. So if we were thinking about that, I could sue Michigan State, and Michigan State is more likely to be able to pay than is Nassar. And so that means that the victims will have a higher probability of recovering their compensation. And of course, when you're making a decision about whether to sue, right, you have to look at the expected value, right? You have to look at what's the probability that I'm going to win, what's the probability of I'm going to get compensated in a certain amount to my true compensation, so that the probability of your being able to be compensated makes it more likely that you'll be able to sue, which means that I, as a potential injurer, will have a greater incentive to try to take proper precaution. If you have contribution, then what's got to happen, as we noted, one defendant has to try to get the contribution from the other, right? So if you have contribution, then the defendants have to sue the other defendants in order to get from the other defendants. They have to get their proportionate share of the negligence that they when they added to the probability of the accident occurring. If you have a no contribution rule, then it gives all the potential parties incentive to take precaution. Right? And if what we have is we have severable liability and we have a no contribution rule, so think about that. If you have severable liability and no contribution, then what's going to happen is that all the potential injurers know they could be sued to put the person back to their original utility function, right? Remember, we're originally talking about what compensation's got to be. It's to get you back to your original utility level. If you have several liability and no contribution, I'm going to know that I could get sued for the whole thing, right? So what will happen is the potential injurers, all potential injurers will take precaution. Now, What that might do, though, is if everybody could be sued in our accident over here, if everybody could be sued for $100, right, then what happened is that the victims might be better off if you have no contribution. The victims might be better off being injured. Right? If what I had was I had severable liability with no contribution, I could sue A for $100, then I could sue B for $100. And if my true compensation, to put me back to my old utility function, or excuse me, my old indifference curve, was $100, I'd be better off if I got injured, because then I could sue A and sue B. And so there would be an incentive for potential victims to go out and try to get themselves in an accident, right? Which is why in the United States, you can't get compensated for more than your total compensation to put you back on your indifference curve, your perfect compensation. So if perfect compensation is $100, again, if I sue A and I get 50, I can sue B, but I can't get more than 50 from B. If you don't allow you to get all the compensation from one party, that is, you have to get part of the compensation. If you have to get part of the compensation from the other party, the other injurer, then what we might call the shallow pockets, the people who have less wealth, will undertake more precaution, right? Then the other injurer will take more precaution. In the example that I gave, where you have this millionaire entrepreneur and you have their driver or something, if I could sue and collect everything from the millionaire entrepreneur or billionaire entrepreneur, then what do I know as the other party? I would know that, hey, you're gonna sue the deep pocket and collect everything from them. I'm going to take less precaution than I would if we didn't have that I knew that I was going to have to bear some of the burden. I'd have to take, if you have with contribution, then I would know that I might have to pay some compensation, and so I'm going to undertake some precaution. Otherwise, if you don't want to set the system up where I just go out and sue who's most able to pay. And of course, when we looked at again what happened with Michigan State, Michigan State was liable, and they paid out the $500 million. And to tell you the truth, I don't know if Nasser had to give monetary compensation or whether he went to jail or not. But anyway, clearly Nasser didn't give $500 million out in compensation. Michigan State did. So you sue the deep pockets here. You probably want to make it so that there's some penalty or some reason for all the parties to take proper precaution. Now, another issue that we might think about is, how do you compute damages? All right, so we're trying to compute damages. Remember what we were trying to do is we said okay, here's an indifference curve where you're starting out with, and remember that we had income and we had health here, right? And we said that if you cause an accident, and what happens is that the victim moves from this point on their indifference curve U1, and you put them on this point over here on their indifference curve U2, so they were at, we'll call that I1 and H1, and now they're at I2 and H2. What do you have to do? You have to get them back to that original indifference curve. And we said that what if if you could pay for their hospital expenses and gave them a little bit of money, then you could get them right back here if they can get their health back. And we said that if for some reason they couldn't get their health back because there was some, they had their leg cut off or something like that, then what happened is that you'd have to move them up to there. If there was some reason they were stuck at H2, you'd have to give them enough income to get them back to that same indifference curve. So if we're trying to think about what the proper compensation would be, that's perfect compensation, is to get the person back to where they were before the injury happened. Now, let's think about what happens if there's no realistic market for what was caused by what the damages were, right? Suppose you have no realistic market. So let's take, for example, somebody kills a child. Okay? How do you find out what the value is of someone killing your child, right? What's the proper compensation to put you back at the true level, where you're back at your same indifference curve? Well, really, there's not a very good way to do that because we don't have a market in that. So how do you do that? Well, if we'll recall what we were talking about, the Hand rule from Leonard Hand, right? The Hand rule, when we were talking about in tort liability, what are you trying to do? You're trying to set the marginal social benefit equal to the marginal social cost, right? What's the efficient amount of precaution is to set the marginal social benefit of the precaution equal to the marginal social cost. And remember that what we said was that the marginal social benefit, what was that? That was the change in the probability of the accident happening, right? And times the A, right? What is that? That's the expected, that's the change in the expected loss, right? Right? It's the marginal, remember what we're trying to do is that we have the total cost of the accident, right, was A, right? That was the cost of the accident. And what are you trying to do? You're trying to change the probability that accident could occur, right? So you're taking proper precaution. And what was that? We had that was, right? P of x was the probability that the accident was going to occur. So what was the expected loss? The expected loss was Px times A. And we said, what was the cost, right? So that Pxa is the expected loss. And what is the cost, right? That we said that we assumed that when, x is the amount of precaution, we assumed that there was a constant marginal cost to having another unit of precaution there. And so W, if we were to increase the precaution, then what we'd be doing, we'd be changing this expected loss, and we said, well, what do? You take the first derivative of this thing. If we want to minimize, right? We were going to minimize Wx plus P of x times A, and so what do you do? We set that equal to 0, right? We take the first derivative. We take the first derivative, right, and set equal to 0. And so what do you get? You get W is equal to P prime of x times A, where this is the change in the probability from another unit of precaution, and this is the marginal social benefit from undertaking precaution, and W is the marginal social cost from undertaking precaution. So what you might do, and in particular, the issue would be what happens when someone is killed, right? So what's the value of that life? Well, we can't just say life is of infinite value, right? Because there are going to be accidents where somebody gets killed and you're going to have a suit that goes on and you're going to have some compensation that gets paid. So you can't just say, oh, life is of infinite value. Somehow the court has to determine here's what the value is. And what the hand rule, using the hand rule, what the authors are talking about is saying, okay, if what we know is we're trying to get to where the marginal social benefit equals the marginal social cost, we could sort of figure that out. That is, we're going to look at your behavior and see what is the implied value of that potential accident. So let's take an example of, suppose that an airbag in your car costs $100. And suppose having that airbag reduces the probability of, it reduces the probability of a fatal accident by 1 over 10,000, right? So I observe you buying an airbag for your car. If I observe you buying an airbag from your car, I'm going to assume that what you did was you undertook the precaution of having the airbag, and you thought that the marginal social benefit or marginal benefit to you anyway, the marginal benefit to you of that extra precaution was equal to $100. So what is P prime x times A? What we know is we've got if we were to look at that equation, we've got the $100 is equal to the change in the change in the probability, which is 1 over 10,000 times A is the loss from the accident. And what does that mean if we take 100 equals 1 over 10,000 times A? If what we do is we solve for A, which is what we're trying to do, right? If we solve for A, what are we going to get? We're going to get 100 times 10,000, and that's going to be equal to 1 million. So the idea would be that you could use an observation about your behavior and assume that what you're trying to do is you're trying to set the efficient amount of precaution and try to maximize that difference between the marginal cost of the precaution and the marginal benefit of precaution. And we would say, okay, I observe you doing this. How much did it cost you to do that? And how much did it reduce the probability of the accident occurring? And from that, I could derive what A is. Now, can you really do that, right? Clearly somebody's got to do it. like I said, there's court cases, there's suits, and someone's got to come up with what the compensation is going to be. And so what this does is this sort of gives you a direction of how you might go about it. The authors in their commentary say they think that that we tend to underestimate the value of those things like life that don't have a true market value. Now, hard to know that. If you are, if you're my age, you might say that, what if you looked at the if someone killed a 5-year-old versus somebody killed a 70-year-old, would you say that, oh, well, the 70-year-old was only going to live another 10 years, and so the compensation from that is going to be much less than the child that was going to live for another 75 years, right? Again, these are sort of things that you can think about when you're trying to put together what the law ought to look like. Just understanding that if you make the law this way, you're going to affect people's behavior. And we've just been using basic economics to go through and say, okay, if we do this, then that's going to encourage these parties to undertake precaution. And if they're the parties that know more about precaution, not everybody's perfectly knowledgeable, and like we were talking about the chainsaw, if the maker of the chainsaw knows more about the precaution than the proper precaution than does the buyer of the chainsaw, either because there's asymmetric information or because of this behavioral economics that we talked about before, you tend to underestimate there's systematic underestimation of the probability of the accident when it's got a low probability. Then we'll put the liability on the producer of the product. So again, it's not like you know what the right answer is. We know exactly how much we're going to value a life, but now we're starting to think through, okay, are there ways that we can try to move us in the right direction? Just as we noted that when we were talking about who values the property right the most, if you have a situation where there are transactions cost, and so the property is going to end up with a party that values it the most, then is there a way I can figure out who values it the most? And we noted that, for example, the stop sign on Milnes Road versus US 12. We sort of know that the people driving on US 12 probably value the ability to cross through that intersection more than the people that are driving on Milnes Road. So what do? We give the property right to the people driving on US 12. Similarly here, what we're doing is we're saying, okay, here's what will happen if you have joint liability where I can sue everybody at once. I only have to make one suit, and what's likely to happen there, right? And I can collect from the group. But there are administrative costs to doing it that way, like how do you decide how much each party of the group has to pay, or that kind of thing. And then severability, it again has incentives for the parties that are most knowledgeable, perhaps, about the issue, to make sure that their other parties aren't doing things. But if it's several liability with contribution, then you might make it so that the parties that don't have deep pockets know that you're more likely to sue the party that has lots of money. And so it's just a matter of thinking through the individual situation and what is the most likely to result in the most efficient amount of precaution, right? Because that's what we're talking about in tort law is what's the efficient amount of precaution that would happen. All right, so for next time what we're going to do is we'll look at, just briefly, we'll look at punitive damages, and then we're going to start economic theory of contract law. So we're going to do chapter 8 on the next lecture on Friday, and we will get through chapters 8 and 9 for the midterm. So the second midterm will cover tort liability and contract law. So over the next few lectures, we will finish we'll go through contract law. So you might just go ahead and take a look at chapter 8 for Friday.